Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5128. Catherine Johnson et al. Appellants versus Xavier Becerra in his official capacity as Secretary of Health and Human Services. Ms. Burrs for the appellants, Mr. Hazel for the appellate.
Good morning, counsel. Ms. Burrs, please proceed when you're ready.
Thank you, Your Honors. May it please the court. I'm Alice Bears on behalf of the plaintiffs' appellants. The issue is whether the plaintiffs have plausibly alleged redressable injuries. The plaintiffs have disabling conditions, multiple sclerosis, quadriplegia. They need and qualify for Medicare-covered home health aid services to help them bathe, go to the bathroom, change positions, activities that are covered under the statute and that are critical to their ability to remain in their homes. But their need for home health aids has been neglected by CMS, the Medicare agency, even though Congress created Medicare coverage of home health aid services for all who qualify and did not exclude people who have MS or other chronic disabilities. Plaintiffs have plausibly alleged that their injuries are redressable by the defendant's secretary. First, the secretary has and relies on a system that's designed to affect home health agency decisions and behavior. The secretary creates an incentive structure with criteria to evaluate home health agencies for quality, to select home health agencies and their claims for audits and reviews. He does that with the purpose and the expectation of changing Medicare home health agencies' behavior. And plaintiffs' relief would make sure that those criteria evaluate whether they, as people with chronic disabilities, are being properly served and that they don't penalize providers who care for patients.
Counsel, isn't this case very similar to Simon versus East Kentucky Welfare Rights Organization? Seems similar in the sense that you're suing an agency alleging that the policies encourage a private third party to do something you don't want it to do. And in that case, the Supreme Court held that was kind of speculative to say that this was caused by the agency.
There are distinctions, Your Honor, and one of the biggest distinctions is the very different relationship between the defendant in Simon and the third parties in that case, and the defendant here, Secretary of Health and Human Services, and the third parties in this case. And in Simon, the IRS commissioner was just the tax official with regard to the hospitals. Here, the Secretary of Health and Human Services, first of all, has a duty to the plaintiffs in this case to ensure that the Medicare program is serving them and serving them safely and also not discriminating against them. And also is the official that certifies the home health agencies. Medicare certified home health agencies are certified by the defendant's secretary in order to provide the services. They have to meet various conditions in order to do that. And the secretary has authority to make sure that they're doing that very thing in a safe and effective way. So the relationship is very different. And
you don't take issue with the general notion that the dynamic in this case involves the decision of a third party who stands between your clients and the secretary.
There is a third party, but I would make 2 points. First of all, the third party here, we can say that there is going to be, we can reasonably predict what the effect of the government action is going to be on this third party. So taking the more recent case law like Department of Commerce and Competitive Enterprise versus FCC, we can say that there is going to, we can say that the government action will have reasonably predictable effects on these third parties. But I would also point out that for the Plaintiffs' Rehabilitation Act claim here, the status of the home health agencies as third parties is less relevant. Not that the standing analysis is different. There is still all of the Lujan elements. But in this, since plaintiffs have alleged this distinct Olmstead injury, unjustified institutionalization or risk of unjustified institutionalization. And that puts an affirmative duty on the secretary to ensure that the program is administered in the most integrated setting appropriate to the needs of disabled beneficiaries. That is non-discretionary duty. He shall administer. He has to make that happen. That makes it very likely that a favorable decision will lead to a remedy that will redress their injuries.
But it's
Ms.
still,
Spears, if I can ask you a question also along the same lines. I mean, one of the arguments it seems that you're making is because these home health agencies are so heavily regulated that the secretary's actions may well predictably affect their behavior. And I understand that argument, but Congress has left these, has left it to private choice, right? These home health care agencies can decide whether or not they want to take Medicare patients. And your argument seems to be that because they're already heavily regulated in other ways, this court can order the secretary to regulate them in additional ways. And so that argument seems to be to raise not only the typical separation of powers problems between Article 3 and Article 2, but also possibly between Article 1, because Congress has specifically left these choices to private action.
Well, thank you, Your Honor. I would say in response to that we are looking at the Medicare statute. I mean, I think Your Honor is referring to the fact that home health agencies, for example, the secretary can't force a home health agency to serve a patient. But Congress also did mandate in the Medicare statute that there's a home health benefit and that if people qualify for that home health benefit.
Well, of course there's a benefit, but the secretary can't force agencies to provide that benefit. That's left to private action.
The secretary can't force a home health agency to serve a patient, but he does create an incentive structure that the agencies predictably respond to, and they make choices based on those incentives. And that's what makes it likely that changing the incentives will change the behavior. But I think what the secretary is not permitted to do is simply throw up his hands and say, well, there's nothing I can do in response to this very real problem of people with serious disabilities being left out of home health aid services that Congress put in the statute. I mean, Congress got that part right. Congress put in the statute that there is a benefit of up to 28 hours per week of home health aid services for those who qualify. Plaintiffs do qualify. Congress put that in the statute to help people and help keep them in their homes. And people with serious chronic disabilities can't be carved out of that benefit. People with MS, people with other chronic disabilities.
Question, counsel.
Sure.
Is there a disparity between the rate that Medicare reimburses the home health aides as compared to the market rate? And what is that disparity?
Well, I'm not sure what the exact disparity is, Your Honor. We do recognize that the payment system with a prospective bundled payments is in the statute. There are private pay rates. In fact, Ms. Johnson, one of the named plaintiffs, is now separately paying private pay, which is not how the home health benefit is supposed to work. It's supposed to be an all-encompassing benefit. We don't force.
Is she paying a different rate when she's paying privately versus getting reimbursed?
Yes. I mean, she's paying, I believe, an hourly rate separate and apart from the bundled rate that Medicare pays.
I'm just trying to get a
health.
sense of the economic incentives for the home health.
Yeah. So
it seems to me that they probably make more money by serving people who are not being reimbursed by Medicare. Is that correct?
By serving people who are not reimbursed
Yeah.
by Medicare?
Right, just
Well,
private parties are just paying more than the people who are getting reimbursed by Medicare.
Yes, I think that may be so. I mean, on our record, what we have are someone like Ms. Johnson who is getting some services reimbursed by Medicare, and then the same agency is also getting private payments from Ms. Johnson for the home health aid services. And
But there seems to be an indication that she can get the services if she's willing to pay more.
if she's willing to pay more, and that is not how the home health
I
benefit
understand
is
that's not how it-
contemplated.
I
Yes.
understand
Yeah.
that's not how it works, but I guess what I'm trying to get at is if what's driving the home health aides not to serve people like your clients is the fact that they're not getting paid as much, then what you're alleging here is not really redressable because the payment rates are set by statute. And so the policies that the agency adopts can't really change that economic dynamic.
Well, I would say, Your Honor, that the agencies are, in exchange for the federal Medicare dollars that they receive, they are supposed to provide a bundle of service in exchange for that bundle of dollars that they receive. And they are not supposed to sort of remove a slice of the benefit and say, okay, we will serve you, but you have to pay for this other piece of the benefit yourself. So what I again don't think that the secretary is permitted here, and especially in light of our Rehabilitation Act claim, can say that because the payment system is there, the coverage of services that Congress mandated can be whittled down, particularly when it results in people like Ms. Johnson or Ms. Bunnell, the other individual named plaintiff in the case, being admitted to hospitals and nursing homes unnecessarily.
But if the reason the home health aides are not willing to serve them is because they're not getting paid as much, what can these other policy changes that you're asking for really do about that? It's not going to change. It's not going to redress the injury. They're still not going to get services if what's driving the decision is money.
So thank you, Your Honor. There are actions that the secretary can take, and I would say, first of all, the secretary does have flexibility under the payment statute. It is a method of administration that's in the injunction, in the proposed injunction, that one of the methods of administration, one of the tools that the secretary has, one of the levers that he can use in creating the incentives is the payment rates that he has the flexibility to set under that statute. And then there's also the targeted.
I'm sorry, you're asking that he change the payment rates?
Well, he does have flexibility under the statute to make changes in how the payment works. I'm sorry, can't say the precise details, but it is, he can change things like the case mix usage, how things are weighted under the statute, which can change the incentives.
I'm sorry, and is that one of the sources of relief that you're requesting?
Yes, it's listed in the injunction as one of the requested relief. And then also the other sort of levers that we're asking the secretary to use are criteria that are used in the secretary's audit and reviews and in the secretary's quality rating measures. Those are also tools that the secretary has at his disposal to change the incentive structure that the home health agencies could respond to.
Make sure my colleagues don't have additional questions at this time. We'll give you a little time for rebuttal if not.
Thank you very much, Your Honor.
Thank you, Ms. Bears. Mr. Hazel.
Good morning, Your Honors. May it please the court, Stephen Hazel for the government. Plaintiffs fall well short of satisfying the high standard this court has set for establishing standing to sue the government based on the conduct of regulated third parties. Plaintiffs allege injury at the hands of independent healthcare providers whose decisions reflect economic factors outside the secretary's control. And plaintiffs separately lack standing because they failed to identify any available relief that would redress their injuries. This court should affirm. I'd like to start with the reimbursement rates argument that counsel brought up earlier. This wasn't something that the district court even thought that plaintiffs had raised. It certainly wasn't a focus of the analysis in district court or in this court. And there's a good reason for that. That's because plaintiffs haven't challenged the secretary's annual rate-making rulemaking. They haven't identified any way that the secretary could set the rates differently that would help them. And that's fatal to their attempt to establish redressability or causation on that basis. I'm happy to answer any questions the court may have. Otherwise, we would urge the court to affirm.
Can you just address the theory that because there's an Olmstead issue in the case, that the normal third-party mediated standing inquiry shouldn't apply?
So, Your Honor, I think that aspect of plaintiff's argument confuses standing in the merits. I mean, there's always going to be an allegation that on the merits, the defendant was acting inconsistent with some statutory duty. But the standing question under Article 3 is different. And here the question is, can plaintiffs establish this causal chain between the injury that they've identified and the particular actions of the secretary that they're focusing on, which are the rates and the audits. And so the causation theory for both the Olmstead claim and their Medicare statute claim is the same, and it fails for the same reasons.
So when you say it's the rates and the audits I get. What do you mean by the rates?
The ratings,
The ratings.
the quality ratings. Apologize.
Okay.
Unless there are further questions, we ask the court to affirm.
Thank you, Mr. Hazel. Spears, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. With regard to the criteria and the audits and the ratings, the overall goal would be to make those criteria more inclusive of the plaintiffs, to make sure that they are not skewed toward, for example, people who can improve, someone who can improve an ambulation, for example. That would not include someone like Ms. Johnson. And just to follow up on the question regarding the reimbursement, plaintiffs alleged in paragraph 58 of the complaint that each year the secretary adjusts and updates the home health payment rates through administrative rulemaking, and the injunction is on JA 58 paragraph 4D was to plaintiffs requested ensuring that payment criteria and methods effectuate reasonable access to aids in the most integrated setting. So the payment is another aspect of the methods of administration under the Rehabilitation Act. Again, one of the tools in the toolbox that the secretary has in order to make sure that the criteria are inclusive and make sure that Congress's intent under the statute is indeed put into effect.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 20-1298, Aly Abdellatif et al. Petitioners versus United States Department of Homeland Security et al. Mr. Garrison for the petitioners, Mr. Waldman for the respondents.
Good morning, counsel. Mr. Garrison, please proceed when you're ready.
Good morning, Your Honors. May it please the court, I am Jay Garrison on behalf of Mr. Abdellatif and his family. This petition for review was filed to allow the petitioners and this court an opportunity to evaluate whether the Department of Homeland Security and its components carried out the proper review of the records they have originated about Mr. Abdellatif. Through their actions in this litigation, the Department of Homeland Security and its components have shown that they did not review their own records of origination and nomination, but instead substituted Mr. Abdellatif's alleged inclusion in a third-party database as the beginning and end of the redress process. For example, DHS has repeatedly attempted to dismiss this action under EG because of Mr. Abdellatif's alleged inclusion in the TSDB, and DHS refused to provide the required certified index of record in its completion due to the alleged inclusion in that database. Only after the opening brief was filed did DHS provide a tailored index of the record, which they again tailored after the reply brief was filed. DHS's production of the record after the opening brief was filed has turned the entire review process on its head in this case. The point of the petition for review is that there is a record. The petitioner reviews that record, the court gets to review that record, and the petitioner writes the opening brief based upon that record. DHS has made a mockery of that process by mangling and tailoring the record to suit their arguments. As a result, the authenticity and completeness of the record in this case is now infirm. Therefore, Mr. Abdellatif and his family request that this court follow its decision in Norris Hirschberg v. SEC and remand this case back to DHS and its components with instructions to complete review and reevaluation of all records originated by them regarding Mr. Abdellatif and his family. The injuries to Mr. Abdellatif and his family in this case are numerous. Based upon Mr. Abdellatif's nationality, religion, and exercise of free speech, DHS has created an ecosystem of derogatory information that is spread across a multitude of data systems managed by DHS. That derogatory information is shared by DHS with private and public, national and international partners. Through its distribution, DHS represents this derogatory information as authentic and properly acquired. It is then used by DHS and its partners to deny and delay travel, financial, and other benefits. This interference and denial of benefits is systematic, continuous, and far-reaching in the lives of Mr. Abdellatif and his family.
So, counsel, if I can ask you, it seems to me that what you're requesting in this case is a review of the records in the databases. But a review of the records in the databases has already taken place. And I guess my question is, why do you think an additional review is going to be any different or yield any different result? And in fact, I believe several reviews have taken place because I think each time you file one of these TRIP requests, a review happens, and I think he's filed 6 of them.
Yes, Your Honor. A review of an individual's identity and whether that identity matches the records is not the same as review of the conclusions as to whether or not that individual is a threat. Under the congressional...
Can I ask you about that? Because it's my understanding of what happens is the first step of the review process is to see if there's a misidentification issue. And if there is not, if in fact the person who's asking for a review is in the database, then there's actually a substantive review as to whether that person belongs in the database. Why isn't that a reasonable way to go about this?
It would be a reasonable way to go about it. However, DHS has provided absolutely no indication that they carried out any subsequent review after completing the initial check with the other databases to see whether or not
there are declarations in the record, 2 of them, which talk about how they do this. And you received a letter from the agency stating that we did a review and we made any changes that were appropriate. And it just seems to me that the record suggests that this is their process and it was followed in this case.
If that process had been properly followed in this case, then the record that was provided to us would indicate more than cursory system updates, and would actually show that further action had been taken to do that review. Just the
But if that is what the record reflects, then you would agree that what you're requesting wouldn't redress anything.
As long as they have fulfilled the specific requirements that Congress set forth to both address the misidentification as well as correct any erroneous information contained in their database, including information that was acquired under improper pretense, then yes, I would agree with that.
Thank you.
Can I ask you the order? So under the statute 46110, you bring a petition to review an order. And the order that you seek review of is the order that you received in response, your client received in response to the trip request?
Yes.
And so for that, part of your substantive claims is a Fourth Amendment claim about the kind of searches that your client undergoes in airport screening. And that the order that you're challenging isn't that search. So how is it that the Fourth Amendment issue with respect to a search at the airport comes to us through the vehicle of a petition for review challenging an order that's a response to a trip request?
The search at the airport is the initial harm that's continuing to be propagated as an injury to the individual that can be potentially remedied through modification of the DHS's databases. And in this instance, the mechanism to question that particular process is to file the trip request when a person has been delayed. And so the result of those delays is the trip request, and the district courts have repeatedly found failure to file the trip request robs a person of jurisdiction to challenge the delays resulting from in their travel because of inclusion in the database. So it's a part of the chain of events that's necessary for this case to even exist. Your Honor, I see that I'm into
can I just follow up on that? So you have parallel district court litigation going on right now in which your challenge, as I understand it, and correct me if I'm wrong, in which you're also challenging searches, but that doesn't have anything to do with challenging an order that results from a trip request. You're just challenging the searches directly as either maybe you're saying that those are themselves are agency action, the conduct of the searches themselves is agency action that you're challenging under the Fourth Amendment or something like that. It just seems like a bit of a, I'm wondering whether it's a mismatch to take that kind of challenge that's to the search as an agency action and then ask us to review an order that results from a trip request and use that as a vehicle to challenge under the Fourth Amendment a search. They seem like two different things.
Well, first, the district court case has now been dismissed, Your Honor. And that case was essentially dismissed due to the conclusion of the court that a decision from a consular officer robs the individual of all jurisdiction, and to challenge pretty much anything that would be in the chain of the history of the case between DHS and the Department of State.
But am I wrong in understanding that in that case, there was a challenge to the searches as themselves action that violated the Fourth Amendment?
That had been raised, and the judge decided that that could not be reached because of the decision from the Department of State, Your Honor.
And it just seems like the order here is the order in response to a trip request. It doesn't immediately strike me as appropriate to use an order that's a response to a trip request to challenge an underlying search.
Well, the trip request is the harm and is part of the standing in the case. You, in order to to make the trip request, you have to have the harm that the individual believes that is occurring, which is the delays, the extended searches, and everything else. And then that leads to the trip request, which then leads into this court, Your Honor.
It could be the injury. I mean, I understand that what you are alleging is inappropriate information in the files begets injuries. But that seems like a different question than whether you can use a statute that provides for review of this kind of order as a vehicle for challenging under the Fourth Amendment, a search that results from what you think is problematic information in the databases.
Well, Your Honor, I believe where we differ on this is not to say that you're differing in opinion.
No. I'd like to know. No, yeah, please help me.
Where we differ is that our position is that the trip request is there, as stated by Congress, to correct erroneous information that has resulted in the misidentification of my clients as threats here. And so our position is that the necessary steps to check for that erroneous information are baked into the trip request process itself. And because that is a part of its process, that gives this court proper authority to review the information that we believe to be erroneous or to have been unconstitutionally acquired.
Yeah, I think as to the information, I totally understand that part of it, because that does go to the purpose of a trip request. I guess what I'm wondering about is a constitutional challenge to the underlying search. Using the trip request, the statute that allows for review and order resulting from a trip request as a means of assessing the constitutionality of the underlying search. But we can ask the government about that too, and we will give you a little bit of time for rebuttal. Let me just make sure my colleagues don't have additional questions.
Thank you. I think I have a question that's related to what the Chief Judge was asking, which is, if you were to get past standing, what would be your argument on the merits? Is this an APA claim that what happened was arbitrary and capricious, or is it a constitutional claim? And if it's a constitutional claim, I'm not sure how we review that, because we don't have any factual findings or review that relate to that. So I'm just not sure how that works. What is your argument on the merits?
Well, at the stage of this case where it's with the process that we've been through to get to here today, I actually think that we don't need to actually get to the constitutional arguments. So therefore, it would be an APA claim for failure to comply with the statute. And we see this way for two reasons. First, DHS did not comply with the statutory requirements, as their focus on Mr. Abdellatif has been his identity and the match of his identity to a third-party database, rather than analyzing their own information that was originated within Department of Homeland Security and its components and has been used to wrongfully identify Mr. Abdellatif and his family as a threat, which Congress has clearly set out. The DHS and its components need to analyze the data within their regimes to assess whether a person was wrongfully identified as a threat and to correct any erroneous information. Secondly, the record at this stage of the case, unfortunately, is infirm due to DHS not providing it before the filing of the opening brief, and then amending it in their response and amending it again after the reply brief. When the court does not have an effective record that it can depend on for the purposes of review, then it doesn't need to even reach the constitutional question here, and instead can remand the case back to the agency per the decision in Norris Hirschberger.
Okay, thank you, counsel. We'll give you a little bit of time for rebuttal. We'll hear from the government now. Mr. Waldman.
Good morning, Your Honors. Joshua Waldman from the Department of Justice for the appellees. There are a number of threshold issues in this case, which I would normally start with, but I'd like to just go directly to the merits first and return to those if I may. The core issue on the merits in this case is petitioners' claim that the government during the TRIP redress process only identifies or only corrects misidentifications and does not engage in a substantive review of any underlying derogatory evidence, if indeed any exists in a particular case. Here, the government has published a public document, the watch list overview, which says that they correct erroneous information if it's appropriate. The responses to petitioners' TRIP redress request said if erroneous information needed correcting, that was done. There are sworn declarations from the agencies describing the redress process in exactly the way that Judge Pan referred to earlier as engaging in that process the petitioner asked for. And of course, there's a presumption of regularity that the government is doing precisely what it says in its public documents and its sworn declarations in this case. And if there were any remaining doubt, you of course have the ex parte record before you. And if there are TSC records in this case, then you would be able to see what the government is doing as part of the redress process. And I understand petitioner's counsel to say that if the government is in fact engaging in that kind of process, that is sort of the beginning and the end of this case. So I would urge you to deny the petition on that basis. With respect
That would be a merits resolution.
That would be a merits resolution, yes. With respect to the Fourth Amendment claim as well, on at least skipping first to the merits, this court's decision in Epic, in agreement with every other court of appeals, says that searches at airports.
So how do we get to that, the search at the airport? Because I'm not sure I understand how we're looking at the actual constitutionality of a search at the airport when this proceeding, it's not a Bivens action challenging a search.
Right.
It's the agency action that's being challenged is the order that ensued from the TRIP redress request.
Right. So I would say, just as a general matter, that airport searches conducted by TSA can be reviewed in the context of a 46-110 proceeding, and that's what this court did in Epic. But the difference between that case,
I thought in Epic, I mean, we were looking at a policy.
you were looking at, well, what the government was doing in that case was, the TSA was doing was conducting an airport search pursuant to its standard operating procedures, which is an order under 46-110. The order here is not that standard operating procedure. It's a different order. It's one coming from the redress proceeding. But I was trying to make just sort of a general point that that's why Fourth Amendment claims can be reviewed if you challenge the right order. And I think the point that you're making is maybe that could happen, but you challenge the wrong order. And I would say, I think that you're right on that, but that is a question, I think, of statutory subject matter jurisdiction and not necessarily Article 3 jurisdiction. So it's something that under this court's precedence, you could just sort of assume, let's assume that we could review it jurisdictionally and then proceed to the merits.
Oh, I was even wondering whether it's a merits resolution, because it just seems like there's a mismatch here in terms of what you're challenging. There is no Fourth Amendment problem with the order that's being challenged. And the order that's being challenged just isn't an appropriate vehicle for looking at the underlying search. So any Fourth Amendment claim just loses on the merits.
I think that that's probably correct.
But
I wouldn't resist winning on that ground instead of reaching the ethics question. So we're happy to win in either way.
But do you think that does go to, do you think that goes to subject matter jurisdiction, that theory, or do you think that goes to the, I was conceiving of it as not having a cause of action to challenge the validity of the underlying search. And I think that the absence of a cause of action is a merits resolution rather than absence of subject matter jurisdiction.
Yeah, I mean, 46-110 is a tricky statute because it doesn't separate out what's the cause of action, what's jurisdictional, what's the waiver of sovereign immunity, in the way that sort of, well, I wouldn't say the APA does that super clearly, but this court's precedent has set that out clearly in Trudeau and other cases. So if I were sort of trying to construct that from scratch, I might say that the jurisdictional provision is in subsection B, which says that something that's properly in subsection A is the exclusive jurisdiction of this court, and that's a subject matter jurisdiction or subject matter jurisdiction provision. And then in A, where it says someone with a substantial interest may file a petition, that's a cause of action question and not necessarily a subject matter jurisdiction
Right.
question. But, I haven't, to be honest, I haven't fully parsed that out. I think that would be a tricky question. But either way, if it's a merits question or it's a statutory subject matter jurisdiction, either way, you could just sort of assume that regardless of the answer under EPIC, the claim would fail. And I think you could just proceed directly to that either way. The only threshold question that I think is truly Article 3 jurisdiction is the EG question. And EG treated it as a redressability problem because the petitioner had not named TSC as a defendant, although it suggested in a footnote that had TSC been named, it would then be a question of statutory subject matter jurisdiction. But in this case, TSC was not named. So I think you have to reach that question first. But that would go only to the extent that the Fourth Amendment or Fifth Amendment or statutory claims were directed at alleged select T-list status.
Right.
But there's also allegations in this case that deal with TSA's risk-based rules.
Open skies and
Quiet skies and.
quiet skies. Okay. Yeah.
I'm sorry, I'm blanking on the name of the other one.
There's a second one. And
There's
is
a
it the
silent
government's
partner.
view that as to those two, to the extent that there's a challenge based on those two, you don't have the same Article 3 issue as was presented in our prior case in EG, right?
Right, or statutory subject matter jurisdiction question. It clearly is a TSA order that fits under 46.110 in our view. And to the extent that that's part of the challenge, it would not be there would be no jurisdictional problem.
So for that one, you just think that goes to the merits to the extent that there's that kind of challenge. But of course,
Yes.
the government is of the view that the claim fails on the merits, but it's not one that gets bounced on jurisdiction.
That's correct. Right.
Okay.
So you would have to reach sort of one of the other threshold issues or the merits question, assuming that's part of the case. And I'm not 100% sure that it is. When we moved to supplement the index of record, we asked to put in material relating to the risk-based rules because previously we did not understand that to be part of the case. And we understood that after the opening brief was filed. Petitioners now sort of objecting to that and saying that some of those things aren't really about the case. So if risk-based rules are not really at issue, you have to ask them about that. But if they're not, then obviously that would just drop out.
Got it. Can I ask you one question? I know that this is not central in the case, but I'm curious about the government's argument
Sure.
that there's a timeliness problem with the Fourth Amendment claim.
Right.
Because the order that we've been talking about is the order that's ensued from the TRIP request.
Right.
And that the action was brought within 60 days of that.
Right.
And even that order itself says this is an order, you can bring an action within 60 days under 46110. But then the government's made the argument that there's actually an untimeliness problem here because the relevant order, I guess, to use the words of the statute, would be when the search occurred.
Right.
Now, how could that be?
Right.
Because
Well, it's a tricky problem. Technically, I think that the answer is that the order is not the search. The order is the standard operating
Got it.
procedure and that's an order.
But
And then
even that's not what the relevant order here doesn't seem to be that. The relevant order here is the one that resulted from the TRIP request.
Right. Well, now you have the mismatch of to get the Fourth Amendment claim in this court under 46.110, I think you would have had to challenge the standard operating procedure as the order and not the TRIP request.
Okay.
And had you done so, then the 60-day rule would apply to the application of that order. So
it
I
gets back
know,
to the issue we started with,
yes.
whether
So
you can actually challenge the underlying search through the vehicle that's.
right.
Okay.
But I do also want to emphasize that in ABA dynamics, this court held that the timeliness question under 46.110 is non-jurisdictional. So again, you could sort of just bypass that. Also, the statute has a good cause exception to the 60-day rule. So for those reasons, I really don't think that you would only need to address it if you got to the merits and you thought the government maybe didn't win, then you'd have to sort of reach all those threshold questions to see whether you could in fact get to that merits question. But if you just think that the government wins at the end of the day on the merits, then you don't need to address those.
Make sure my colleagues don't have any.
I'm sorry, on the constitutional claims, That was never raised before the agency. There was never a discussion of the Fourth Amendment or the Fifth Amendment or anything. So why are you entertaining those arguments before us?
Well, I mean, I'm just arguing in the alternative. I don't necessarily think that they
But
are.
you conceded there was jurisdiction to consider constitutional claims, but they were just never raised before the agency. So normally we wouldn't entertain them, right?
Well, I think that I'm not sure that that's entirely correct. For example, the person doesn't know until they get to the end of the process that they're challenging the process itself as being like not giving sufficient notice, for example, or not giving certain evidence. And so I think that they can raise that in this court only
Raise
because
the
they.
Fourth Amendment?
Well, I think they could raise a Fourth Amendment question if they were challenging the correct order. So this is sort of the
I'm
mismatch
just saying
between
in
the
this
orders.
particular case.
In this particular
We're
case,
looking at an order in which
yeah,
there was never any mention of the Fourth Amendment,
yeah,
either by the petitioner who asked for a review or by the agency
Right.
making the review.
Uh,
And then he comes before us and makes Fourth Amendment arguments and claims, and you concede that we should consider them. And I'm just
Well-
wondering why.
Well, the only jurisdictional thing that I'm conceding is the one about the risk-based rules, which I'm not quite sure is in the case. And I don't think that they need to sort of say the words risk-based rule in their redress application, but
So you
the
think
re-
risk-based rules equates to a Fourth Amendment violation?
I think that that's the way that they're framing it. I think they say.
But you're allowing them to, you're agreeing.
Well-
You're not contesting it, is I guess what I'm saying.
What I'm saying is, to the extent that they're arguing that their enhanced security screening at an airport derives from the application of a risk-based rule, that this court would have jurisdiction to entertain that claim. So we're not contesting that part.
But as a
But-
Fourth Amendment.
Yeah, I mean, I can see the argument both ways, but in the redress complaint, they did say we were searched and we were subject to this type of search. And I think you could fairly say that that was intended to raise a Fourth Amendment claim. I could see why maybe you wouldn't, but I'm not sure that we want to necessarily hold people who file these claims to that type of lawyerly particulars when filing a redress claim.
And I just want to make sure I understand, can you explain, if we think that because there have been extensive reviews done already and the relief requested is an extensive review, and we think therefore perhaps it's not redressable because it doesn't show that if we grant the relief requested, it's going to address the injury. Do we need to go any further than that? Because it seemed to me that you were saying that there are some things that we would have to address on the merits even beyond that.
No, I think that saying the review has already happened answers both the statutory claim on the merits and the due process claim. As I understand it, on the merits, you might have to say something separately for the Fourth Amendment claim, which is not about that issue. But I'm not.
But you're saying on the merits, and so that's not a.
Yeah.
If you say that the review is satisfactory
Yeah.
because it actually goes beyond misidentification and encompasses whether information needs to be corrected, the way you conceive of it is not as a jurisdictional question about redressability. That's a resolution on the merits in the government's favor.
Right. I mean, I think that would probably be because, like, imagine a hypothetical world in which the government did not engage in that process. You would be able to redress it by saying, in theory, the statute or the due process requires you to do it. So the fact that we've done it here doesn't mean that you couldn't conceivably have an order to redress the posited injury. It would mean that we've actually on the merits done the very thing that the plaintiff. I understand why.
I'm thinking about this a little bit differently, so this is helpful to me
Okay.
because I was thinking about it in terms of there needs to be evidence of standing at this stage of the proceedings. It can't just be allegations.
Right.
And we're looking at evidence that there was a review, and we're looking at a request for relief, do another review. And there's no evidence that another review is going to redress the injury. And so it's a standing issue to me. The fact that there was a review and another review won't redress the injury would be a standing issue because there has to be evidence of standing where we stand here today.
Right. I understand that point of view. That's not really the way that I was looking at it, but I'm happy to win that way also. Or alternatively, but I would say, I mean, there's a question then of how much you look beyond the pleadings. when deciding a jurisdictional question, which I think that you
But
can.
wait a minute, we're at a stage where we're looking at evidence. There has to be evidence because we have case law that says, when a case comes to us in this posture, it's like a summary judgment standard, not a motion to dismiss type standard, because that's the way it's come straight to us from the agency. We have to find evidence of standing.
Right. I mean, I understand that. I'm not going to resist whether it's a victory on the merits or on standing. I think this type of claim is so unusual and rare that it's probably not going to have a large impact on other cases. And I'm not going to resist saying that it's a standing problem.
No, I'm just trying to understand what's the right answer.
Yeah,
I know you want to win however we decide this, but I'm trying to decide what is the right answer.
Yeah, I mean, I do think that from my point of view, I think it's a merits question, but I understand. I mean, this is one of those areas where the question of standing and the question of the merits often bleeds together. It's hard to necessarily separate them. But I came at it from the point of view of, let's assume that the plaintiff was correct on the merits.
Which we always do for purposes.
Right. So would they have standing if they were indeed correct and our evidence didn't exist or was all? But on the other hand, I also say, like, can you just sort of assume that's all correct in the face of just the government has all the evidence on the one side and there's nothing counterbalancing, and maybe that's a different type of situation. So I know that answer really didn't sort of help to resolve the standing versus the merits, but I do think that my instinct says that it's merits, but you know, that I confess that I haven't fully thought that out before this argument. If there are other questions, I'm happy to answer them, and I'm sorry to go down on the rabbit hole on so many of these tricky threshold questions.
We ask you questions and you try to answer them. We appreciate that. Make sure my colleagues don't have additional questions for you at this point.
Thank you.
Thank you, Mr. Waldman. Mr. Garrison, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honors. The government here shouldn't be entitled to the presumption of regularity due simply to the irregularity of how they provided the record in this case, which raises a substantial question to the regularity with regards to how they handled the case before the trip decision was ever issued. You know, they started here with a very short 5-part index of record that they wouldn't provide any of the documents to the petitioners from, and they claimed that to be under oath a complete record. Then after the opening briefing is filed, they claim again that they've provided the complete record, and they add a lot more documents. And then after the reply brief is filed, they claim that again that they suddenly have a few more records to provide and that it's now a complete record. So the presumption of regularity, quite frankly, has been defenestrated, thrown out the window in this case throughout the process. From there, where we go with this for us as for the petitioners is that I want to just briefly touch on that, the naivety of a petitioner in how they formulate the question when they are filing their initial trip request. That process is designed in a manner where the individual puts it forward to the best of their language and is really encouraged to be done by the individual, not by a lawyer. And so their naivety in formulating it and not putting forth all the evidence possible that would support a Fourth Amendment request or anything else, it shouldn't be held against them. In fact, where we end up in a position with is that the only opportunity to get that record to really have them have something to respond to is at the stage in this case, preferably prior to their opening brief. Unless Your Honors have any further questions, then thank you very much for your time today.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission, and the court will take a brief recess.
Everyone needs to read the courtroom except for the attorneys in the third case and the law.